God save the state and this honorable court.
Good morning. Our next case is in the matter of J.N. and L.N. We'll hear from the appellant.
Good morning, Your Honors. May it please the Court. My name is Benjamin Cull. It's my privilege and honor to represent the father in this case. First, I'd like to say just thank you very much for the opportunity to have this discussion today. Of course, this is a very important issue for my client and his family, but of course the outcome of this case has the potential to impact every single parent in North Carolina. Can a court grant custody of your child to somebody else over your opposition without ever concluding that you are an unfit parent? The Peterson Presumption says absolutely not. The Peterson Presumption is the well-established constitutional rule in North Carolina which recognizes that a parent is presumed to be fit. Practically, then, that means that if a court is going to grant guardianship of your child to someone else, the court must first conclude that you are an unfit parent. Otherwise, without that conclusion, the decision to grant guardianship or permanent custody to a non-parent, that type of ruling would offend the Due Process Clause. That's what this court has told us. That type of order would offend the Due Process Clause. But that's exactly what happened here. The trial court granted guardianship of my client's children to somebody else, despite his opposition, without ever concluding that he was an unfit parent. So he appealed to the Court of Appeals, and the Court of Appeals said, sorry, you can't raise that issue because you did not raise a constitutional parental rights argument, that was their language, at the trial court. Never mind the fact that he actively opposed during the hearing, put on evidence, testified himself, opposed the guardianship, and the court never concluded that he was an unfit parent.
Why wouldn't the respondent father be required here to expressly articulate his constitutionally protected right to preserve those rights? We do have those kinds of articulations in the law to preserve records. You've got to make certain motions to preserve the record in some matters, have to make certain objections during jury instructions. You have to make certain utterances. Why would that not apply here?
Your Honor, I think there's three answers to that question. These are the three main points that I'd like to cover today. I think the first and the most important, and the answer that I think should dictate the outcome of this case, is that this issue is automatically preserved for appellate review under Rule 10. Right? Alternatively, if the court does not agree with that, the issue is still preserved under Rule 10 under the Court of Appeals logic and reasoning in the BRW case, which is the case that's actually up next today before this court. Right? In that case, the court conducted an analysis to determine whether, despite the lack of any explicit raising of a constitutional argument, did the fact that the parent opposed the government's request for guardianship, was that in and of itself enough to implicitly invoke the Peterson presumption? So that would be the second reason. The third reason would be that affirming here, ruling that a parent can waive this important constitutional right is directly contrary to the public policy of our state, both the legislative public policy and the executive public policy as stated in DSS's own policy manual. So as to the first question, Your Honor, the automatic preservation, right? What does Rule 10 say about automatic preservation? Rule 10 preserves automatically a certain number of different issues, one of which is, quote, whether the judgment is supported by the findings of fact and the conclusions of law. That's an issue in every case that is automatically preserved for appellate review. Right, this court has already told us that the Peterson rebuttal is a conclusion of law. Right, the case from last year from this court, In Re IK. There's 3 IK cases cited in the briefs. 2 of them are Court of Appeals. There's 1 IK case from this court. And in that case, this court conducted conventional, are the findings supported by clear and convincing evidence? Do the findings support a conclusion of law? And one of those conclusions of law in that case was whether the Peterson presumption had been properly rebutted. So the rebuttal of the Peterson presumption is a conclusion of law. Right? The Peterson line of cases, Adams, OMB, Price, they all tell us that a guardianship order must include a Peterson rebuttal. Because if the guardianship order does not include the Peterson rebuttal, it offends the due process clause. It's an unconstitutional order. In other words, the Peterson presumption is a conclusion of law that you must have in every single guardianship order. So under Rule 10, it's automatically preserved. Right? That's a very, very brief argument, but those are all the details that you need to get to the answer in this case. Those details dictate the outcome of this case. Right? The Peterson rebuttal is a conclusion of law that is automatically preserved under Rule 10 because it is a conclusion of law that must be in every guardianship order. Now, it bears noting that the appellees had no arguments in response to this point in their briefs. Right? The guardians were the only of the three parties that even tried to put forth an argument about it, but they completely overlooked the relevant portion of Rule 10. Right? They did acknowledge that Rule 10 does automatically preserve some issues, and then they pointed to irrelevant portions of the rule. They said, well, jury instruction issues, plain error issues in criminal cases, those are automatically preserved. Of course, not relevant here, but they completely omitted any mention of the portion that's relevant here, whether the judgment...
Mr. Cole, typically, if you have a conclusion of law, that's a legal determination that is to be made based on the findings, and at least if it's done correctly, if I understand it, what you would do would be to look at the findings, and then the court, be it a trial court or an appellate court conducting de novo review, would look at those findings and determine whether the applicable legal standard had or had not been met. Is assuming that that's a correct understanding of what we do when we have a conclusion of law, why couldn't the appellate court on review simply determine, I mean, your argument before was there's no conclusion on this subject, therefore remand or something of that nature. Can the appellate court just look at it on appeal and then make an independent new determination of whether the constitutional rights of the parents are breached?
I would say no for two different reasons, Your Honor. And this is one case I cited in my memo.
And I'm not trying to get into whether the court here ought to rule on whether the constitutional standard was satisfied or not. Just can an appellate court generally in the first instance make that determination?
Right. I would say no, Your Honor. When a trial court fails to make a conclusion of law that's required in cases like this, in child welfare cases, it happens all the time, and those orders are routinely remanded. Right? In termination cases, perhaps the most common example is dependency cases, when the trial court needs to conclude that there was a lack of alternative caregiver. Right? We see that regularly. Whenever the court fails to make that conclusion, the Court of Appeals...
Aren't those typically, though, cases in which there are evidence that could support various findings of fact? The findings of fact weren't made, and therefore the case was remanded to the trial court for determination of what the facts were? Isn't that typically what happens in those cases?
Well, I think it depends on whether we're talking about findings of fact or conclusions of law. So, I think perhaps another way of considering it is the Coble case. The Coble case in my Memorandum of Additional Authority talks about the need for a trial court order to be complete, for it to be subject to appellate review. Right? In the Coble case, this court talked about every link of the chain in a trial court's reasoning.
I think we're all familiar with Coble. It gets cited probably as much as anything that we see.
Right, so without that conclusion of law, right, if you cannot look at the trial court's order and see that the trial court did make a conclusion that the Peterson presumption was rebutted, then we have no way of knowing that the trial court even knew that the Peterson presumption existed. right? And then we're assuming that the trial court would have decided to grant custody if it knew that the Peterson presumption existed and that it had an important constitutional question to answer. So if we look at a blank order that does not include the answer to that important constitutional question, we have no way of knowing whether the trial court did its job and considered the important constitutional rights that are at issue here.
I want to ask about your response to what I understand the Department of Social Services to be arguing regarding the fact that in a case like this, unlike Peterson, in a case here where there's been an adjudication of abuse or neglect, that is arguably a per se determination that the parent has acted in a manner contrary to their protected status, at least in this particular case.
Your Honor, I think the important point to emphasize there is this court's decision in Montgomery, which, like Coble has cited ad nauseum perhaps, for the important point that an initial adjudication, neglect adjudication, is about the child's condition, not about the question of parental neglect. Right? In this case is a perfect example of why that is so. Right? We had a baby with very bad injuries show up at the emergency room. DSS immediately became involved, of course, as they should, and investigate and figure out what happened. Right? By the time it came up for the but even if you had a determination of parental fault, right, then the question becomes, does that determination in the initial adjudication order have a preclusive effect down the road, for example, in a termination order or in a guardianship order? And I would say no, because again, under Montgomery, at the initial adjudication order, parental fault is not on the table. So it's not an issue that's essential to the judgment. So if you're asking whether under issue preclusion then you're prevented from relitigating that question, I would say no.